Mediation is a good way to avoid potential uncertainty with the jury. Mediation is essentially using the tool of a third-party neutral, which is a judge, typically a retired judge, and that third-party neutral is able to bring his or her wisdom and experience to the case in a way that can typically bring about good resolution. The first step in mediation, of course, is that both sides have to agree to it. So once both sides agree, then both sides agree to the mediator. So the plaintiff, of course, has input in who the mediator is and which mediator is selected. And once that's determined, then the next step typically is for us to file our individual reports on the cases. So what that means is we, the plaintiff's attorneys, prepare a submission to the judge, to the mediator, outlining all of the strengths and merits of the case. It's confidential, so the other side doesn't see it, and the other side does the same thing. After that, on the day of mediation, what occurs? So both sides can do an opening statement if they want to. I like doing that because it's an opportunity for me to speak to the adjuster who's present. It's my time to speak about the strengths and the merits of the case to the insurance company directly. And I also find that doing that helps to move things along and to focus on what really matters in the mediation. After that, the parties will split up. We'll go into a room with the plaintiff, and the defense attorney will go into another room typically with the insurance adjuster. And the judge will walk back and forth, relaying offers, demands, settlements, sometimes making recommendations and also offering his or her wisdom and input on where the case is headed. I find the mediation to be very effective, and we at Emroch Kilduff, we've used it. We've done many of these over the course of years. We've been around for a long time, and we are experienced using mediation and other ways to favorably get cases resolved. Mediations are favorable in the sense that you are not bound to accept the terms that are proposed by the other side. The plaintiff gets to you get to either reject or accept that potential offer, and you're not locked in the same way you would be with a verdict. So you can refuse. And so I think that gives people a little more comfort going in, because they know that no matter what happens, they're not required to accept what's offered. The plaintiff's attorneys are there with the plaintiff through the entirety of the mediation process. So we stay with you throughout, we make recommendations, we talk to you so that you have full information about making appropriate responses, and we make recommendations all the way through. So I think sometimes people find it to be helpful if they are concerned about putting their issues in front of a jury, which is potentially, it's a group of strangers making decisions for you. And so mediation is a way that sort of relieves some of that concern that the parties may feel. There are other tools besides mediation that are available. One of those tools is arbitration, which is similar to mediation in that the parties agree to a judge, and the parties agree to have the judge make determinations as to the outcome. The difference is arbitration is binding, so it's the same as or very similar to a verdict, which means that at the end of the day, at the end of the arbitration, the judge actually makes a ruling, whereas in mediation, it's up to the parties themselves to accept the terms that have been